Dr. Lucy Gibbard, Medicolegal Consultant with Medical Protection. I'm here today with two of my colleagues, Dr. Tim Cookson and Dr. Sam King.
Hey, Lucy.
How you doing?
And today we are talking about what are your risks with ACC treatment injury claims. So look, today we're discussing the unique no-fault compensation system that we have in Aotearoa, New Zealand, the ACC, or the Accident Compensation Corporation. Tim tells me it's also got an rehabilitation in there somewhere now these days as well. So look, we're going to start with a bit of history because ACC is a very unique organisation in the world. So I thought we'd talk a little bit about how it got set up, because it was set up following the Woodhouse Report, which came out in 1967, which talked about the system of workers' compensation that was in place at the time. When there were complaints that the compensation wasn't enough to support workers who were off work. So that report recommended a new no-fault accident compensation programme, not just for accidents at work, but for all workers in New Zealand, whether or not they were at work at the time of the accident, and also for all motor vehicle accidents. And it also recommended at the same time removing the right to sue for any type of personal injury. So look, this report led to the Accident Compensation Act in 1972, a few years later, which was modified later, even before it came into force, to cover students and people who weren't working, including visitors to New Zealand. So now, anyone who's actually physically in New Zealand is covered by the Accident Compensation Act. In 1974, the Accident Compensation Commission was established, and that was to manage that compensation programme. Since then, there have been many amendments to the system, including a big one in 2005, which was of particular interest to clinicians. Because at that point, Parliament passed the Injury Prevention, Rehabilitation and Compensation Amendment Act, which replaced medical misadventure, which is a word you still hear a lot these days, even though actually it's not in our legislation anymore, with treatment injury. So that meant that ACC could cover anyone injured during treatment. So ACC provides help to pay for costs of an accident's victim's recovery, also including payments towards treatment, help at home and work, and help with their income. So what does that system mean for clinicians in New Zealand? And what are the medical legal issues for providers within the system? So, Tim.
Yes, it was good that the ACC changed it. It used to be there was both medical misadventure and medical mishap, and the difference between the two was that mishap was supposedly where there was no fault, but misadventure was where there might have been a fault. And the treatment injury provisions now, very specifically, it's not an attempt to find fault. So when a patient suffers as a result of provision of treatment, they're not required to prove that someone was at fault and that led to their poor outcome, which is the cornerstone really of that process, that there's a lack of requirement of proving fault.
And very different from the judicial system elsewhere in the world where people sue their doctors, and to get compensation they have to prove fault.
Exactly. And the other critical thing about an ACC treatment injury claim is that it's not a complaint either. So it's not someone saying you're at fault, you've done wrong. It's just, I have suffered as a result of this treatment, and I'm going to apply for assistance with that through the ACC. So from that perspective, it's brilliant for clinicians in New Zealand, and for MPS members, it's the sole reason why your subs are so low in New Zealand compared with virtually all the other jurisdictions in the world that MPS operates in. So we have great cause to be grateful for ACC, but it's not entirely without fishhooks, and we'll be talking about some of those a bit later, I think, as well.
Yeah, well, a lot of us interact with ACC as providers of medical services as well. And that's actually where the patient's just had an accident. It's nothing to do with treatment. And ACC helps to pay for their medical costs. And look, I don't think there are any significant medical legal risks in caring for accident victims above and beyond what our normal professional obligations would be. So one of the issues that does come up, though, is about the patient's privacy when they're being treated under ACC. Sam, can you give us a bit more information on that?
So when patients apply for ACC cover, they will sign an ACC 45 form, and in signing that document, the patient consents to ACC to have access to their medical records relating to that injury and its treatment. And patients, I think, need to be aware, and most of them are quite happy for their information to go to ACC, because if they don't, they can't get cover at all. But I think for some patients, they do need to be aware that perhaps some sensitive information might be going to ACC.
So signing an ACC 45 form is actually something we should be talking to patients about, and I don't know if many of us do that, is actually saying when you sign this form to get cover for this accident, actually you are, by signing this, allowing ACC access to information relating to that accident. And I don't know how often we actually specifically say to the patient, that's what you're signing, but they are.
And it can start to get complicated as well, because we all have received those letters from ACC wanting all the notes back to 1922.
Yeah. Yes.
And the difficulty there is that we can only provide the information that is relevant to the injury. And we have to exclude all of the other information relating to cervical smears or sore eyes or whatever that didn't apply. And we've certainly had cases involving privacy complaints where information has been provided that was not relevant and may have been quite sensitive to the patient or the consumer, and should not have gone to ACC. So we do have to be careful about that provision of information.
But you do sometimes have to provide information prior to the date of the accident. Because if the patient is claiming for an accident about their right knee, ACC may want information about anything to do with their right knee prior to the date of the accident. So, it is one of those things that you just got to be a bit careful about, isn't it? So, and also in the modern world with telehealth, it's actually created a whole new issue, because obviously we do telehealth consultations for ACC, and generally in those situations the patient isn't signing an ACC 45. So how do we deal with that?
I think it's probably a timely reminder that the consultations that we run by telehealth are held to the same standards as if it's an in-person consultation. And so it's important that we have patient consent to the use of telehealth as a means of them accessing care, and to be aware of the limitations of telehealth. And obviously we all realise that a lot of that's around our inability to examine physically. So if you're filling in an ACC 45 form, you need to carefully document that the patient has consented to the claim being made on their behalf, and that they have also consented to ACC having access to their health information regarding that claim. Now, most of us, of course, say to the patient, I'm just going to fill in the ACC form now and take the time to do that. And so patients are aware. In some instances, I am aware of some doctors who want to claim ACC but don't necessarily tell the patient, and I would suggest that that's not an appropriate thing to do. Patients need to be aware, because ACC will contact them and say, we've received this claim that's been lodged or an application that's been lodged, and you don't want the patient then to go, well, actually, I didn't agree to that, because unusually there are some patients who do not want an ACC application to be made, regardless of the fact that they would be covered if they did.
ACC have actually got a really good telehealth guide on their website, and they do go into the issue of what's going to happen in a telehealth consultation if the patient isn't going to sign an ACC 45. And they have 3 questions that you're supposed to read to the patient during the telehealth consult, and document that the patient has agreed to all these things. So you're supposed to ask the patient, do you declare that you have provided true and correct information? You'll tell ACC if your situation changes. You're supposed to say yes. Do you authorise me as your GP to lodge a claim with ACC? It's supposed to be yes. And do you authorise your records to be collected or disclosed to ACC to help determine cover for your claim, determine what you'll be entitled to, or for research processes? And that's supposed to be yes. And all those answers are supposed to be recorded into the patient's notes. Now, I have to say, from reading doctors' notes over the last 2 years, I don't think I've seen many doctors actually doing that. And look, to be honest, I haven't heard of a complaint about this yet. But I can imagine that in the future, there may well be issues where the patient hasn't said, no, the doctor never read out that list to me, and no, I haven't agreed to ACC accessing my notes. And then later on, when the ACC sends a letter to the doctor saying, can we have access to the notes, and the doctor provides them, then the doctor will have breached that patient's privacy because they won't have done that consent process properly. So I think it is a risk and something to bear in mind, and that if you are a doctor who does telehealth consults, do look at the ACC telehealth guide and see what you're supposed to be doing for consent.
And there's another potential area for medico-legal issues in relation to telehealth consults for ACC injuries, which is that obviously you can't do a proper physical examination of the injured bit of the body. And it's easy to envisage the situation where ACC rejects a claim because there's not sufficient evidence that an injury occurred. And the reason for that is that you haven't provided or been able to provide examination findings. And so you could get a complaint from the patient that their claim has been rejected because you didn't say, actually, I need to see you in person for this rather than trying to do this via telehealth. You'll need to make an appointment so I can examine you. So again, it's a reminder that you need to think very carefully about any consultation you're doing by telehealth to make sure that there's not vital information that you would gain from an examination, and that you therefore need to recommend that the person be seen rather than just have a telehealth consult.
There's another little fishhook in the ACC telehealth issue, which is about we are more and more having doctors who are overseas and doing work while they're overseas, and there are all sorts of issues, and maybe again we'll have another podcast about that later. But one of the things that is very clearly specified for ACC is that the doctor and the patient must both be in New Zealand when the service is offered. So if you are on holiday in Australia and you're doing your inbox and you provide an ACC report, or you do a telehealth consult or provide a certificate, you're not allowed to do that. You actually, the doctor and the client both need to be in New Zealand for any telehealth provision of care. So now I think we're going to go on and talk about actual come away from telehealth and talk about treatment injury claims. So what is a treatment injury? Sam?
Treatment injuries are basically harm caused by treatment from a registered health professional. The patient must consent to the claim being lodged. And in the DHB's ACC claims are sometimes lodged for issues such as a post-op wound infection as a way of assisting the hospital with getting funds, but it's still necessary for the patient to be aware of this and consent to their health information being shared with ACC. So essentially, a treatment injury claim can be something similar to an antibiotic reaction, a rash caused by medication that's been provided, or it could be as serious as a delayed diagnosis of cancer.
Yeah, and that's quite a common one that we're seeing these days. So, Tim, what are the core requirements that need to be met for a treatment injury claim to be accepted by ACC?
Well, there are three primary bits to the equation, really. There has to be an injury that has occurred and that has resulted in physical harm or damage to the patient. The injury has to have been caused by the treatment, or as Sam said, by delays perhaps in treatment or diagnosis. And also importantly, that the injury is not a necessary part or ordinary consequence of the treatment. So, for example, your appendix scar is a necessary part of the process. Psychic surgery is not practiced very often in New Zealand, so you will have a scar after your appendix is removed, and you can't claim ACC for the presence of the scar alone. But you might be able to claim a treatment injury claim if there was a significant infection afterwards that resulted in, for example, adhesions or something of that nature. And the criteria seem to have changed over the time, and we're not quite sure what the criteria are in terms of the rarity of an event for it to be accepted by ACC as not an ordinary consequence.
Yeah, and the other thing is obviously the underlying health conditions of the patient also have to be taken into account. So if a patient has an underlying health condition that actually was in a large way causative, that makes it less likely that the patient will have that treatment injury claim accepted. So if a patient has severe heart disease and is needing to have surgery and is warned about the high risk of having a heart attack, if they were to have surgery, they know about the risk, they take that risk and go ahead with surgery, it's possible that ACC will take that into account, their underlying heart disease, in refusing a claim if they later go on to have a heart attack. So we talked a little bit about that fact that treatment doesn't necessarily just mean treatment. What else does treatment mean as far as treatment injury is concerned, Sam?
With regards to ACC, it includes diagnosis, failure to provide treatment in a timely manner, or failing to obtain consent, and a failure of equipment. So treatment is viewed very broadly by the ACC.
Yeah, so not treating is treating, really, as far as ACC is concerned as well.
Yeah, that's right, where you haven't treated where you ought to have treated.
Where you ought to have treated, yeah, which is a little bit, counterintuitive, really, isn't it? The fact that actually not treating somebody for something counts as a treatment injury.
But it kind of covered more broadly as it's an injury that occurs during the provision of treatment.
Yeah.
But,
or failure of provision of treatment.
Exactly.
Yeah, okay.
Yeah.
So the issue, and probably an increasing one these days, is about whether or not a treatment wasn't provided because there weren't resources to provide that treatment. Tim, can you tell us a little bit more about that kind of situation?
Well, yes, there is an issue related to resource allocation, and ACC will not cover a patient whose condition has deteriorated while they were sitting on a waiting list. So you can certainly envisage someone's condition getting a lot worse as a result of having 6 months before they're operated on, but ACC will not cover that, which seems like an anomaly in some ways, doesn't it? Because it's what's different from that from, say, a failure to diagnose properly. And
so if your doctor fails to write the referral letter and that's the reason your surgery is delayed, you will get cover. Whereas if you've actually just sat on a waiting list for all that time, you won't get cover.
That's our understanding. Yep.
I guess the first one is an error. The error was, or the omission was, that you weren't, the referral wasn't sent.
But it's a no-fault scheme, isn't it? So
that's
the error
true. That's
but actually, the point is that the resource allocation is the issue for them, isn't it? That they can't, if you haven't been provided the service because there weren't the resources to provide it, ACC are not covering everything. And I can imagine the claims would be enormous if everybody who's couldn't get their hip replacement in time because there aren't enough hip replacement, that all got covered by ACC. I don't think ACC would cope with that.
Could increase the complexity significantly, couldn't it?
It could.
It also, things that are not covered include, if your patient's desired outcome was not achieved, then that is unlikely to result in a successful treatment injury claim. But certainly the delays, specifically or particularly for failure to diagnose cancer at an earlier stage, are one of the common things that we see with ACC treatment injury claims. The difficulty there is, of course, hindsight bias applies dramatically because you've had the cancer diagnosed by the time people decide to make a claim, and then looking back over the notes and deciding whether a specific symptoms met the requirements or the need for an investigation
at that time.
Yeah. So there's significant area for debate around that one.
And a lot of that will come down to the expert opinion again, won't it?
But also they won't cover, so if a lung cancer diagnosis is delayed, they won't actually cover all the issues of having lung cancer. They'll only cover issues that would have got worse because of the delay. So the entire lung cancer isn't covered, it's actually just that part of it which was caused by the delay, which is also very hard to quantify, I just thought, So when we're thinking about a patient has been harmed in the course of medical treatment, who generally is going to be best to fill in an ACC form for that patient? Sam, what are your thoughts on, if there has been an injury, who's the best person to fill in that claim form?
Technically, any clinician can fill in the ACC Treatment Injury claim form. It is usually best for the clinician who provided the care to do that because they'll have the facts to hand. It's not uncommon for an entirely different clinician who may not have access to the previous clinical notes to do that. And that's simply because the patient has gone to a different doctor, moved doctors. Invariably, ACC will ask for a report from the clinician, and our suggestion would be that if you weren't the clinician who provided the initial care, that you pass that request on to the doctor concerned. It's not uncommon for those reports to be sent off by a different clinician without all of the information necessary for the expert to be able to determine whether the care was good or not. And that has certain implications for the doctors at hand. So the best person really is the clinician who provided the care. Sorry, that's a long answer.
No, so the person who provided the care. And
which is sometimes a bit tough because particularly if there was a significant error, you've made a mistake, you're then having to provide a report, outlining your mistake. There are a couple of issues that arise. One is that sometimes we see doctors who think, if I make it clear that there's been a problem, then actually my patient is going to be more likely to get the claim accepted, and that'll be good for my patient, and that'll be fine. But that, of course, isn't the best thing to do. So doing a kind of a false mea culpa is not a good move to support your patient, because if the ACC's assessors decide that there's a risk of future harm of the similar sort of thing occurring again, then by law they're obliged to report that to the regulatory authority. So that would be the Medical Council. And so you certainly don't want to have the Medical Council being involved in your competency assessment or whatever, just because you've provided information to ACC that either wasn't complete or wasn't sort of totally accurate. So in those situations, we'd certainly advise contacting Medical Protection to get advice on providing information to ACC, because we really want the assessor to have all of the relevant information so they can see, that yes, an injury may have occurred, but it wasn't due to some concern about the performance of the doctor, and therefore they don't have to invoke that bit that involves them referring to the Medical Council.
And I think that's one of the things that clinicians often find quite frustrating, is that at the point where the ACC medical assessor is looking at that case, they won't ask for clarification or for further information from the clinicians involved. They'll make their decision about whether to refer to the Medical Council based on the information they were given, without going back to the clinician and saying, am I right about what I've understood about what happened? And so a doctor can find themselves referred to the Medical Council or a nurse to the Nursing Council without actually having had the chance to point out to the ACC assessor that actually that isn't exactly what happened, or there were mitigating circumstances, or it was a resource issue. So I think that's one of the reasons why we want the clinician involved to be the person who makes the report, because they then have the opportunity to make sure that they have all that information, because ACC assessors aren't going to come back and ask for that information if they don't have it.
And one of the additional problems that then occurs is just because someone's put in an ACC treatment injury claim doesn't mean that they won't also put in a complaint to the HDC. And if that happens as a complaint to the HDC, often the ACC assessor's report will be provided to the HDC as a so-called expert opinion. And we've seen lots of cases where the HDC has been influenced by those opinions, even though they were for a different process, and even though the unlike the HDC expert opinions, as you say, there's no opportunity for the doctor to comment and to point out inaccuracies. But inevitably, if it's critical, the HDC will become somewhat biased by the fact that they've got this report. And it's one of the things that we've often tried to challenge with the HDC, that they've taken, in our opinion, too much notice of an ACC report, which doesn't have the safeguards that their own expert reports have.
And I think that risk of a referral to the medical council, I think most doctors probably haven't got that in mind when they're filling in an ACC treatment injury claim form. They're looking at it from their patient's point of view and thinking, well, look, my patient will get compensation. And so they may actually slant it to try and allow the patient to get compensation, as you said, Tim, rather than actually trying to actually lay out the facts objectively. I remember a case I had a few years ago where an obstetrician was looking after a woman in labour and was wanting to do an emergency section, and unfortunately there was no theatre available, and the baby suffered as a result, and there was an ACC treatment injury claim, and the obstetrician got referred to the medical council because they said there was a delay in the Caesar, because the ACC assessor had no idea that in fact that obstetrician had been trying really hard to get theatre time and hadn't managed to get a theatre. It would have been so much simpler if actually the clinician involved had actually been involved in providing information to ACC. It went through the medical council process and it was all fine. You know, she explained herself to the medical council, but actually that's not something that any of us want to be doing. And I think we can all agree that actually giving the ACC assessors as much information as possible is probably the best way to go.
Yeah, as much information as possible, but it's also it's the accuracy of the information.
Yep.
I mean, as you say, not to slant it in any way, because, I mean, you have to think this is a legal document you're signing here, and it's important to be accurate rather than biased.
Do you think doctors can actually refuse to fill in an ACC treatment injury claim if they're worried about being referred to the medical council? Can they say, no, I'm not going to fill in a treatment injury claim for you?
Well, you have to be... you have to have some reason to believe that an injury has occurred, because as Sam says, you're signing a document to say there has been an injury. And if you genuinely believe that no injury has occurred, then that's kind of a tricky situation to be put in. I'm not aware of any cases where doctors have been challenged for submitting a claim when there was no obvious injury. So, some doctors might choose to take that course rather than having an unhappy patient who then complains that the claim wasn't lodged by them. But it's not a straightforward decision, and it may just be that we haven't yet seen that case where a doctor has been criticised for putting in an ACC claim where there was no justification for doing it.
I think that another aspect of that is when a doctor understands that there was an error or there was perhaps an injury caused by something they did or didn't do, and they don't want to go down that road of being referred to the medical council, we can be tempted to be a little biased. And I think that it's the patient's right to have access to ACC if it is warranted. And if you don't feel like you can put in the claim, then you could always refer the patient to another clinician to do that.
But I think you would be criticised if a patient wanted to file an ACC treatment injury claim and you refused to do so because of your concerns about an error having occurred. That's exactly the right reason why there should be an ACC treatment injury claim.
Yeah, if you're perceived as being defensive, that certainly wouldn't be a good thing. Yes.
But I think the other thing in those situations is to actually make sure you do call your indemnifier in those situations. If you're actually thinking that the ACC treatment injury claim may lead to a risk of referral to the medical council, it would be really good to call your indemnifier before you put that claim form in, just to make sure that actually it's the information has been provided appropriately, and that the ACC assessors have got what they need to make a correct decision.
And we certainly help a lot of our members, don't we, write treatment injury reports. So please do call us if you're our member and you're in that situation.
But also, if you happen not to have done that, and the first you know of it is getting the letter from the medical council asking for an explanation, again, we're very happy to assist in that situation. And actually, the good news is that our general impression is that, apart from the effort of having to, provide a full explanation to the medical council, very few of the doctors who have been notified by ACC to the medical council end up having any sort of formal competency inquiry. That would be pretty uncommon in my experience.
Yeah.
So it's a hassle, but it's likely that the outcome will be fine. But yeah, it's a hassle that would be a lot better avoided by having all of the relevant information provided to ACC in the first place and getting advice on that process.
And I think, we've all been talking here about saying, the clinician involved should be the person to fill in the form. What if you're not the clinician involved? What if the patient comes to you and says, I believe I've been harmed in the course of medical treatment by this other provider. Can you fill in an ACC claim form for me? But you actually don't have any information about it. What would you do then? So,
I think that, on the actual application form, the initial form that you put in, you don't need to provide an awful lot of detail. Just the bare minimum is fine. ACC will request a full report, and that can be provided. And if that request comes to you and you're not the primary clinician, I would suggest you forward it on to whoever is the primary or was the primary clinician so that they can do that. It's in the patient's best interests, it's in the clinician's best interests.
I often think as well, though, as a GP, sometimes you could say to the patient, look, this issue has been arisen with another provider. Would you be happy for me to talk to that provider? Are you happy for me to actually ask that provider to fill in the form because they've got the information? And if the patient says no, well, then obviously you're not going to proceed. But it may be that actually you could actually refer it to the doctor who has actually been involved to get them to fill the form in for the patient.
But the bottom line probably is that, no, if your patient comes to you and says, look, I've been injured and this is what happened, I want you to sign the form, then, yep, you've got to go ahead and do it.
Okay. So thank you, guys. I hope our listeners have gained some insight a bit more into how the ACC treatment injury process works and also into ACC telehealth. But look, if you've got any specific questions about specific cases, our members are welcome to call us on our advice line, which is 0800 2255 677, or you can email us about specific cases on advice@medicalprotection.org. If you want to contact us about this podcast or with suggestions for any future podcasts or subjects that you'd like to hear us talking about, you can email us on podcastsnz@medicalprotection.org. So thank you very much, Sam and Tim, for sharing your experience today, and thank you to our listeners for listening. I hope it's been helpful. We look forward to catching up with you again at our next podcast. If you like Medical Protection podcasts, please subscribe and leave a review. Thanks, Tim and Sam.
Thanks, Lucy.
Cheers, Lucy.